Welcome to Citrin Cooperman Corner Chats. I'm Peter Katz from West Fair Communications, publisher of the Westchester County Business Journal, Fairfield County Business Journal, WAG Magazine, and digital newsletters to keep you fully informed. On this edition, we'll be exploring an area that too many people don't like to deal with, yet can be vitally important for the destiny of a business and the future happiness and prosperity of those associated with any business. And I'm talking about estate planning. And let's face it, we may not like to admit that we're mere mortals. And estate planning is not only important, but can be complex, as we'll learn from three of Citrin Cooperman's experts, all CPAs. Howard Klein, leader of the Trust and Estate Group at Citrin Cooperman, is a tax planner with more than 30 years' experience in the areas of tax, financial, estate, and succession planning. And welcome, Howard.
Thank you very much for having us.
And we also have Heather Oboda, a tax partner at Citrin Cooperman with nearly 2 decades of experience in public accounting. She's an active member of the firm's trusts and estates practice. And good to have you with us, Heather.
Thank you for having me today.
And Patti Iengo is a tax partner at the White Plains office of Citrin Cooperman with more than 20 years of experience in public accounting. And she also is an active member of the firm's trust and estate practice. Patti provides tax compliance and consulting services. And welcome, Patti.
Thank you. Thank you so much for having us.
And Howard, we're going to begin with you with something which is really quite current, and that is the changes that are going on in Washington as we speak. And can you tell us what President-elect Biden's tax proposals are as they relate to estate and gift taxes?
I'd be happy to, Peter, and I appreciate that introduction. Yes, it is a very complex area. So the post-election estate planning discussion centers around 3 proposals that the Biden campaign laid out prior to the election. The first of these proposals is a reduction of a current lifetime estate and gift tax exemption of $11.58 million per person, which that number had been doubled at the end of 2017 when Donald Trump became president. So the first area of uncertainty, and what we don't know is going to happen, is we don't know what's going to happen with this exemption going forward. Once the Biden administration takes over, there's a lot of speculation that that exemption of $11.5 million or so could be halved. It could go even lower. We're just not sure. The second proposal that is being discussed and was on the table was a potential increase in the top estate tax rate. Currently, that's 40%. And again, we were reading that they were talking about maybe 45%. And this rate has been as high as 55% not too long ago. The final proposal is actually the biggest area, and we'll go into more depth of that during this conversation. And that's the repeal of what the step-up in basis rule is for assets inherited at death. Again, we'll go into that in a little more detail. What's kind of fascinating is that it's almost impossible to talk about taxes these days without understanding the political landscape. They have to go hand in hand. As hopefully most of our listeners know, that there are 2 Senate seats that will be contested in early January, and that will indicate which party controls the Senate. This is not a political conversation. This is an estate planning conversation. So we should bear in mind that anything that might be done next year, it could be, we don't know what they're going to do, what areas they're going to impact, and most importantly, what effective dates are going to be imposed. For example, they could do something later in the year and make it retroactive to the beginning of the year. So we still have this whole level of uncertainty surrounding everything. And, right now we're looking at the current environment for our clients who are doing estate planning, and the environment itself is very, very favorable. First is that with all these potential changes, we still have about what's now a narrowing calendar down to almost maybe 4 or 5 weeks left to get something done for this year to take advantage of what we know is a higher exemption. So people should consider it. And in addition to this, right now interest rates are at historic lows. And asset values may have also been reduced, some significantly because of the pandemic. So these things create an environment for continuing to talk. A lot of people said, well, we're just going to push this off. And our philosophy is have your discussions with your CPAs, your estate planning counsel, other advisors. And if it's possible to potentially make gifts now, and you want to make gifts, and again, we'll go into that in a little bit more detail, it's still a very, very favorable environment. So with that as a backdrop, I'll turn it back over to you. Thank you.
Well, I want to bring Heather into this. And Heather, in your experience, can you give us more specifics as to how these proposals, things that might happen, could possibly impact people in business, people in trying to preserve their assets for their heirs?
Great, happy to. So as Howard was saying, the exemption may go down from the 11.58 million. They're saying to historical levels. What does historical levels mean? It may go back to where it was before 2017's Tax Cut Job Act was enacted, which would mean it would be about $5 million adjusted for inflation. So let's call it $6 million. So now you're going from an $11.5 million exemption to a $6 million exemption. So if the tax rates stay the same, you've automatically started having a $2 million additional tax bill to the IRS if your assets are at that $11.5 million range where you would have had no tax liability. And now, with a decrease in the exemption, you now have a $2 million tax liability, or I should say your heirs and your estate does. Also, as Howard talked about, the repeal of the step-up in basis. What is a step-up in basis? When someone passes away, the assets are stepped up in value. So, for example, if I buy an asset, shares of stock for $100, and they go up to $900, there's a gain of $800 there. But if I pass away prior to selling this asset, my estate, if it's a non-taxable estate, still the security goes up in value to $900, and then my heir would then sell the stock and have, if they sold it the next day, there would be ultimately no gain or loss. However, in this new proposal, my heir would get my $100 basis, and when they sell that stock for $900 or whatever they sell it for, they are going to have to pay capital gains tax. Now, also, I don't recall if Howard mentioned, they're talking about increasing the capital gains tax for long-term capital gains from favorable ordinary rates of 20% to, from favorable capital gains rates to ordinary rates. So that could mean having the gain be taxed not at 20%, but closer to 40%, which would impact all estates, not just those that are taxable federal estates. So these are things that our clients need to take into consideration. I will warn you guys that in planning, I know some of your listeners are from New York and from Connecticut. For our Connecticut clients right now, the estate exemption and gift exemption for 2020 is only $5.1 million. So if someone wants to gift up to that exemption, there is potential exposure if they go over the 5.1 million lifetime gifting. There is also exposure if they passed away today with assets over 5.1 million. And in addition, New York also has not an exemption per se, but a cliff. And if someone passes away with over $5.8 million of assets, they will have a taxable estate also. So there are other considerations, not just the Biden plan, that should be taken into effect when working on an estate plan with your estate planning advisors.
Now, Patti, for you, given what we've heard from Howard and Heather and some of what we're hearing from around Washington, D.C. these days, what are you telling your clients to do for the balance of this year? And to what extent can you predict what they should be doing for 2021?
Well, as Howard mentioned earlier, without knowing the control of the Senate, current estate planning is even more difficult. Any of the changes can be retroactive to the beginning of the year if they do make some changes. As also Howard mentioned, the current environment is favorable to gifting because of the interest rates being at historical lows, and the values of assets may have even been reduced, some significantly due to COVID. But now with the possible changes in the tax law and the potential decrease in the exemption, what we're discussing with our clients before year end is reviewing their current estate plan, discussing their goals and objectives. If they haven't used up their lifetime exclusion and they can afford to do so, we're discussing the ideas of making gifts now rather than delaying when we're not sure what could happen. And these gifts can be done in various formats with setting up different types of trusts. And we collaboratively discussed this with their estate attorneys, combined with them. Ultimately, it is the client's choice, as they need to be comfortable with gifting away their assets. Some clients have a hard time with gifting it away, but at the end of the day, they need to be comfortable with it. As far as the future, it's very difficult to say without knowing for sure what's going to happen.
And Howard, back to you. When you meet with clients, what do you particularly look for, other than the size of the balance in a bank? What do you look for, and how can you help them with their planning?
Very, very, very good question. So I like to take the approach very consistently with every client. We ask them to give us their financial information, as you just mentioned. What your net worth is, not only how much, but also what types of assets you have. Not all assets are created equally, and in terms of what assets may appreciate, in terms of getting these things out of your estate. So we sit down and we say to our clients, give us all your financial information. Give us whatever legal documents you have, trusts, wills, etc. And what we do is we map out for them what would happen if they did nothing. Very, very simple. Everybody has a plan. Some plans are good, some plans aren't so good. So once we report back to them, this is what happens when you do nothing. They then ask us very often, well, are there any other alternatives that you might suggest? So we start to use our kind of skill sets and again, potentially collaborative with attorneys and other types of advisors to see what can we do, what steps can be taken. Again, following up on what both Patti and Heather said, specifically Patti, we want to make sure that if we are going to recommend that clients discuss making any gifts, thereby moving assets out of their estate, that those assets are needed in terms of them benefiting from the cash flow from their own lifestyle. We don't judge. We're just reporting. And also, even if they can afford it, we have to prove the math to them. They might still not want to do it. There are, however, a number of techniques that can be used to kind of have your cake and eat it too. There are certain types of trusts that give away the assets to children for the future. And if you're going to make these types of irrevocable gifts, the money's generally not going to come back to you. So the asset is out of your hands. You can't get the income. You can't get the principal. However, there are certain other types of trusts, and I'm not sure what time frame we have, that kind of allow you to benefit a little bit from the income, for example. So there's a lot of flexibility. I think flexibility is important because, as you can see, there's things changing constantly. The laws are changing constantly. It's virtually impossible to do this generational planning now. But we're involved in many cases, and we're trying to get a lot of things done before the end of the year. If your assets, for example, are not liquid assets like stocks, bonds, and cash, but they're tied up in closely held businesses, those businesses need to be valued to see what it is, what the value of the business is worth. And we also deal with liquidity issues, both from do people have enough money to live on? And also, will there be an estate tax that would come due without having the type of liquidity needed to cover any potential estate tax? We don't want our clients to have to be in a position where they have to sell assets or mortgage them that they don't want to, sell or mortgage. So I hope that answered your question, but that's a little bit of the process. And we try to be consistent. And then once you start talking to the client, whoever they may be, spouses, et cetera, you begin to get a sense of what their assets are. And also, most importantly, this is their plan. What do they want to accomplish? And then it kind of drifts off because everybody's different. I use the term, and I'm sure Patti and Heather have heard this too much. Everybody's a snowflake. Everybody has different views of things, and these are really individual plans. And so that's the process. In a world of uncertainty, flexibility is even more important.
And Heather, without violating any confidences or saying anything unethical, have there been situations where you've been with clients and they just have not been able to deal with one's mortality, and you really had to do almost a selling job in order to get them to take the business of estate planning seriously?
Yes, I will say that more of my clients have become more open to the idea of planning. Unfortunately, during the pandemic, it has basically brought everyone's mortality to the forefront. So they are starting to have conversations that I may have been trying to have with them for years. It may also be everything coming up with the potential changes in the exemptions that has been scaring them also. But yes, I have to hound them sometimes and, tell them it is important. Let's just at least review the situation, at least see where your assets are. You don't have to do anything, but I want you to see what your plan, if it's no plan at all, what the impact is going to be for the next generation or for your spouse. What's going to happen? So yes, these are conversations. These are hard conversations that I have to have with my clients. And it can be difficult at times, but I feel that it's very necessary, and I'm happy to sit with them. And it could take a period of time for them to come around to the idea, but they're starting to come around at least a little bit. And at the end of the day, they can say, I don't want to do it because you're the client, you are allowed to do that, but I need to give you a full report as to what your exposure is, so that no one comes back and says to us, you didn't do your job at helping us or advising us. That's the worst thing that could ever happen, is someone saying, well, why didn't you bring this up? So that's why I'm persistent with my clients on this matter.
And Patti, for you, again, without violating any confidences here or being unethical in any way, are there situations where you actually have taken a look at someone's financial situation, taken a look at the estate, and been able to produce a situation where there was a genuine and substantial savings in terms of tax liability for the client?
Yes, on numerous occasions we've done estate planning where we have helped the client save a lot of estate tax, and with the planning that was involved. So there has been many cases where we have, and to kind of piggyback a little bit on what Heather was saying, I've also had situations where a client, although they agreed that the estate planning will save them tax dollars in the future for their generations, they still were uncomfortable with gifting because they either didn't want to lose control or they just weren't comfortable with gifting. And although, we've explained it to them and they understand that at the end of the day, there could be potentially a huge tax liability when they pass away, they were okay with saying, it is what it is. I'm just not ready to gift right now. So we try our best to show our clients the benefit to the plan, and it ultimately ends up being their decision and their comfort level.
And now, Howard, for you, if I'm a business person and I call up Citrin Cooperman and I say, help, what is the process? What do we have to do in order to start to set me up so that I'm going to be able to pass the most to my heirs and not to Uncle Sam?
Well, the first step is we have a complimentary call If it's an existing client, it may be a client of another partners in the firm where they have the client relationship. Those relationships are vital. They know the client. They know the client's family. Sometimes we're brought in just as a subject matter expert assisting other partners in the firm with their clients, or sometimes it's a potential new client. So we ask them, like I said previously, first of all, do you want to undertake this? I think you hit the nail on the head at the very beginning. Not many people want to deal with this. I think the crisis and the pandemic has brought a little bit of people's attention to wow, this could really impact me. And one of the things I try to get people to engage in this is to say that with respect to most things in their world, especially some of our successful business owners, they're pretty much in control of everything. They understand their business, their type A personalities very often, yet they'll allow their estate plan to be the chance. And I caution them when they undertake the process that this process will be sometimes little painstaking. They have to gather a lot of information. There's costs involved that they have to bear. It's a little frustrating. You're dealing with professionals. Although the benefit will not be for them, it might be for their children. If they're lucky, their children will appreciate it. Do you still want to do it? So that's the way I kind of preamble this. But and then once an existing client, a potential client wants to speak with us, we get a sense of where they might, where their assets are, like I said before, and we give them that complimentary, kind of look. As Heather was mentioning, it's not just, how much tax could potentially be paid or saved, but also what assets do you have, where are they going? And it's very, very personal. I've often said that estate planning is financial information, legal documents combined to help the clients accomplish what their goals and objectives are, including their fears. So you're dealing with a lot of emotional issues here. You're dealing with children. If it's family businesses, or that some children may be in the business, some children may not be in the business. It creates some very, very interesting conversations in what used to be conference rooms, and now these are calls like this. So I don't know if I answered your questions specifically enough, but I want to give you a sense of what our approach is. And with respect to one of the questions you asked, I think you asked Patti, we just recently finished an engagement for a client that was very much involved in this. We got their attorneys involved, and we created, we had the attorney, we don't draft, we have lawyers on staff, but we don't draft documents. We actually created a couple of trusts where the clients will actually have access to the income from those trusts, as long as they're both alive and married. And eventually, in this particular case, their family will ultimately save about $16 million of estate tax. Again, not for them, for their family, but it certainly hit home. And when you show clients, especially on graphs and circle graphs and bar graphs, what true savings there could be ultimately over a lifetime as assets appreciate, it could really ramp up in terms of passing on value to their children. So all of these factors kind of go into the soup, and then the person in front of you, the client, is going to lead the conversation based in our direction based on what they're trying to accomplish.
How do you rank the complexity of the estate field in accounting compared with other accounting practices you do? Handling the books for a C corp or an S corp. Where does estate planning rank on the scale of complexity?
Well, I think it's a great question. I think it's very complex, and one of the reasons why it's very complex is you're not only dealing with numbers, which the typical accountant situation is. You're looking at books and records. How did my company do? What are my expenses? What's my revenue? How much tax do I owe? Maybe you get involved in some more soft skills like their personnel, et cetera. But when it comes to estate planning, as I've just mentioned, I probably talk to just as many attorneys as I do accountants, because you're really on the cusp of the legal community. That's why we, in our Citrin Cooperman dedicated trust and estate practice, we brought in lawyers who are trust and estate attorneys to bridge that gap between the legal and accounting community. So you're really on the cusp of overlapping the tax area and the legal area. Not to mention, and I think Heather made mention of different states' exemption levels, but states have different rules also. There are rules for how, California's community property. New York doesn't have community property. Some states have a state tax. Some states don't have a state tax. Where do you live? A lot of people say, well, I have a house in Florida. I'm now a Florida resident. It's not that simple. It's where your domicile is, where you make your home. So you're getting involved in a lot of different areas. And that's why I've always felt, at the risk of sounding like a commercial, being part of a bigger establishment like Citrin Cooperman allows us to bring in those niche individuals who really can address, for example, we have a state and local tax group. So I don't think it's to me, it's not just simple tax work in the traditional sense that everybody, recognizes on April 15th. I think it's much more than that. Plus, as people's lives continue to move forward, and there are all these different types of events, getting married, having children go to college, having children grow out of the home, they get married, they have children. This becomes a lifetime of planning. I'm not saying you do this every year, but it becomes, when you hit these milestone events, you have to circle back and say, does the plan I put into place still work? Is it still effective? And for all those reasons, I think this makes this a little bit more complicated. And one of the reasons why I got involved in it, because it's both accounting, legal, but also a lot of family, sometimes even a little bit of psychiatry and family therapy, as you can imagine. So I find that fascinating. I don't know what it says about me, but I actually enjoy those conversations.
And Heather, let's build on that for a second. Is there anything that you find particularly fulfilling about this line of accounting work?
I like working with the families, and I like showing them the different plans, the different scenarios. Helping to get the wealth to the next generations is key. So if it's not making gifts now, but it's doing some sort of planning or including maybe an insurance trust or some other asset vehicle to protect the family's wealth. Or if the family is charitably inclined, maybe talking to them about doing some charitable gift giving now that will help their future generations, which is wonderful. So, for example, right now, one of our clients is working on, actually probably a lot of our clients are working on these type of gifts to charitable lead annuity trusts. And what happens is, for example, you put $1 million into a charitable lead annuity trust, and for 10 years, if $50,000 gets paid out to the charity of your choice or charities, and then at the end of the term, the remaining assets, which right now, based on a growth rate of maybe 8%, the assets are going to go either in trust or outright to the children or to a grandchildren's trust. So these are wonderful vehicles, and I feel like it's a great way to preserve the family's assets, and also they're getting a charitable deduction. In my example, the clients are getting a $489,000 charitable deduction right now for giving out $500,000 basically over 10 years. So there's a time value of money, and there have huge income events right now because a lot of clients are possibly liquidating their accounts or liquidated their accounts back in March before everything happened. So the stock market is still crazy. So we're still seeing large capital gains. So these are great ways to not, I wouldn't say shelter, but mitigate the income tax effect. So these are the type of plans that make me feel good when, all of the client's needs and wants are basically wrapped up in a bow, and I'm able to give them a solution to a problem. I feel very happy.
And Patti, building on what Heather just said, to a certain extent, we were warned maybe a year or so ago that you started to hear that because of the tax changes that had been put into effect, charitable giving was now a bygone era. Is that still the case? And how can, in planning for an estate, you help your favorite charities?
I feel that charitable giving is still a main factor in a sense for high net worth individuals. And what I notice with some of my clients is that once they feel that their kids are set in terms of dealing with their estate planning and they've gifted enough to their kids, they feel like, okay, now I'd like to give to charity. And what are the vehicles that I can use? And some of them are what Heather mentioned with the charitable. There's various charitable trusts that they can use, that they could either gift now or even set up that when they pass away, it can go to one of these trusts. And or even when they pass away, some go to charity. I had an estate where they had taken care of all of the other beneficiaries and whatever with dollar amounts or percentages, and at the end of the day, whatever was left was going to charity because they were charitably inclined. So I feel that charities, the charitable giving, I'm noticing with a lot of clients, they're still doing it even, currently and as part of their estate plan.
And in the couple of minutes we have left here, let's go back, beginning with Howard. And what would your message be to people who are facing having to plan for their estates?
Well, I think that the biggest message is what you actually just said in your question, which is their estates. So I would ask almost a rhetorical question. Shouldn't your plan be your plan, not based on some law or some judge somewhere? When you put it to writing and you, kind of take responsibility for it and put the time into it, it can reflect what all of your wishes are. And don't leave it to chance. Don't leave it to, other people to do it. Don't wait. Like I think Heather said, just because we don't tell people what to do. We make recommendations based on what we see. We discuss it with them. We give them some financial assurance and stress test everything that we suggest. And yes, the larger estates have, I guess, more flexibility potentially, but it depends on people's lifestyles. So we don't judge a book by its cover. We can help almost anybody, but know what you have, where it's going. When you have young children, it's extremely important to address these things. It's not just how your money is going to be dealt with between, let's say, two spouses, but also what are they going to do with their children? How's the money going to go to their children? Is it going to go outright? Is it going to go in trusts? If you leave it to the law, there could be children that are, of majority age, over 18, inheriting different types of sums of money, which could be a burden to them. Inheriting a lot of money from an economic point of view, not a personal point of view, sounds like a windfall, but sometimes it's a burden as well. And so, plan it out. It's like anything else in life. The more you put into it, the more it will reflect, your goals and your desires. So that's what I can't stress, more strongly enough.
And Heather, your thoughts? You concur with what Howard just said?
I do. I will add that in addition to, reviewing your plan, I would suggest reviewing other documents, reviewing your insurance policies, making sure that you have enough life insurance, even house insurance, car insurance, all of these things people should look at least every few years. They should review their will, make sure it makes sense, make sure that it's not old and out of date, that the trustees or executors that you had planned are really the people you want having control at the end of the day. Again, the tax laws changed a few years ago, and there's a difference between state and federal exemptions. So be very careful if you have an older document to just make sure that you don't put $11 million into a credit shelter trust in New York State, which would create $5 million over the exemption, and therefore your estate has a $1.3 million tax liability on the first to pass away. I had that, and it's not pretty. It's not nice thing to discuss with the surviving spouse who thinks that there's nothing due with the original estate. So we can't always fix what comes to us after the fact. We can only fix what comes to us before the event, or making sure that the documents have flexibility, that if there's a provision or a change in the law, that there's the ability to change it up by the executor, or someone has the ability to disclaim the assets, moving it from one bucket to another. So these are things that people need to take into consideration. Also reviewing their IRA beneficiaries. If your IRA beneficiary is your ex-wife, you don't want your IRA to go to your ex-wife, then because it's not part of your divorce agreement for whatever reason, you need to review that. You also wouldn't want to have your IRA go straight out to your estate, because that means that it's not going to your beneficiaries right away. There's other complications to the transaction. So I just really hope that clients or potential clients look at all their documents and just make sure that they make sense to them, and speak to their advisors, because that's what we're all here for, is to help in these situations.
And Patti, the last word is going to be yours. What should the takeaway be from this session today?
I think the biggest takeaway is what we've all been saying, is just take a look at your estate plan and make sure that it still makes sense, and talk to your advisors about it. Just to make sure that everything is buttoned up and as best as can, and you're taking advantage of any estate planning at this time that you can.
And I thank all of you for joining us on today's edition of Citrin Cooperman's Corner Chats. I'm Peter Katz of West Fair Communications. Have a very great day.